right now.
This meeting is being recorded.
Sorry for that interruption. I would like to tell you all that I will be speaking for the motion, and the motion, as it is already been clear, is that Indian arbitration law is compatible to safeguard confidentiality concerns. Now, the first limb of the argument is I want to introduce this concept and make sure that everybody knows, being the first speaker, what confidentiality is and how it is being introduced in the Indian arbitration law. So in 2017, a high-level committee headed by Justice B.N. Sri Krishna had recommended that the provision related to confidentiality be codified and introduced in the Arbitration Act to ensure that it is a statutory obligation upon the parties, the arbitral tribunal, the arbitral institution, to maintain confidentiality of the arbitration proceedings. So the intent was to ensure that there is no level of disclosure with respect to certain confidential information which forms part of the arbitral record. Pursuant to this high-level committee report in 2019, the Amendment Act to the Arbitration and Conciliation Act had introduced this provision, Section 42A. I would like to read out the provision to ensure that everybody understands what it says. 42A says confidentiality of information, notwithstanding anything contained by any other law for the time being in force, the arbitrator, the arbitral institution, and the parties to the arbitration agreement shall maintain confidentiality of all arbitration proceedings, except award, where its disclosure is necessary for the purpose of implementation and enforcement of award. Now, to break down this provision, in my opinion, this is the provision which is actually pretty airtight and takes care of all the confidentiality concerns. Now, this provision begins with the non-obstante clause, which says notwithstanding anything contained in any other law. So the intention to identify what was the intention behind introducing this non-obstante clause is that to ensure that it overrides any other law. So in case disclosure is mandated or required by any other law, the Section 42A being a 2019 being introduced by 2019 amendment will definitely override any other law, and confidentiality is therefore protected. The other protection this non-obstante clause also provides is that Arbitration Act, as we know, is a special legislation. So in case of conflict, if it arises between any other special law or with any other general law, this being a latter enactment will definitely prevail over any other act. Now, in case of conflict, firstly, the intention is to ensure that the courts read the provisions harmoniously in case there is any conflict with any other act. But since this is the latter provision, the understanding is that this is going to prevail over the other acts. The other, to break down the other part of this provision, it says it binds the arbitrator, the arbitral institution, and the parties. So therefore, no third-party interference is allowed in the arbitration proceedings, and the proceedings remain confidential in nature. The only limited exception it has is that for the purpose of implementation and for enforcement of the award can be disclosed. Now, the other why this provision is also strengthened is because this is it is based on an implied concept of confidentiality, which is also prevalent in other countries with in their arbitration law. Even in absence of any codified law, there is an inherent understanding that arbitration proceedings are understood to be confidential in nature because they are based on a party autonomy concept. Secondly, even if provision is limited to ad hoc arbitrations. However, even if parties opt for an institutional arbitration, the Delhi International Arbitration Center, and even in fact in Mumbai, their rules specifically also have provisions for confidentiality. So this is the second argument that I had. Even if somebody opts for ad hoc or institutional arbitration, the confidentiality is protected. There are more number of exceptions, however, in the rules provided in the Delhi International Arbitration Center rules. It offers more number of exceptions for disclosure. However, in case the parties are at nowhere in any law prohibited from protecting confidentiality by. I'm sorry, my voice is opening.
No, I think Kamal wasn't on mute. You can continue. It's not echoing.
So my argument was that even in terms of institutional arbitration, the confidentiality is very well protected, even by way of the rules contained therein. Now, the other thing is that the provision section 42A, which has been introduced, although it contains it contains the word shall maintain confidentiality. However, courts in numerous occasions have read the word shall as directory and not mandatory in nature to ensure that the legislation is harmoniously read. So, however, essentially the courts have also understood that the object behind understanding whether a provision is mandatory or directory in nature, and to interpret the word shall cannot be done just by reading the word literally. The object and the intention of the legislature has to be understood behind it, which has also been identified here. So the reason for mentioning this right here is that since this provision is only directory in nature, parties are free to institute any other confidentiality clause if they wish to in their arbitration agreement itself, which is not, there is no bar in instituting. However, in absence of any such clause, the parties are protected under this provision. That's, I think, all I have to say. Do I have some more time?
Pinto, is the time 1 minute left, Dilsheen?
Okay.
30 seconds now. I mean, you can conclude it or you can actually take it up later in rebuttal. I would let you have those extra 30 seconds then.
Yeah, I'll do that.
All right, perfect. Thank you so much, Dilsheen. It was lovely to hear you. I would request the second speaker for the team speaking for the motion, Tanya, to come ahead and give her points of this.
Very good evening to everyone present here. My name is Tanya and I'll be speaking for the motion. The motion, as already has been explained by my co-speaker and Jayashree ma'am, it is Indian arbitration. This house believes that Indian arbitration law is compatible enough to safeguard confidentiality concerns. Now, the meaning of this would include that the existence of an arbitration agreement, the subject matter, the evidences, arguments, arbitrators award cannot be divulged to third parties. It also goes ahead to mean that the parties, their legal representatives, and people who are specifically authorized can only attend the arbitral proceedings. Anybody apart from that, if attending the arbitral proceeding or divulging the contents to third party would mean a breach of confidentiality obligation. Courts, as we are all aware that arbitration proceedings are of private nature, unlike the court proceedings. The arbitration proceedings arise out of a private contract which governs the obligations of the parties. Dilsheen has already dealt with the section 42A, which majorly deals with the confidentiality obligation in an arbitration in the Indian context. To take that forward, the Indian arbitration regime or any regime of arbitration arises or takes inspiration from the arbitration agreement. The arbitration agreements, as practitioners, we are all aware that almost all arbitration agreements contains a confidentiality clause. Even when even in cases of ad hoc arbitration, section 43A is prevalent, and in case of institutional arbitration, as already pointed out, DIAC has a provision for confidentiality. MCIA also has a provision for implied confidentiality. However, in cases where these provisions are absent, even in those cases, parties can opt for confidentiality by way of including such a provision in their arbitration agreement. One of the major concerns that scholars believe in this that there exist in this particular section is the question of sanctions. what happens when there is a breach of a confidentiality obligation? In my opinion, there is enough safeguard in the Indian arbitration regime to protect the interest of the parties with respect to confidentiality. In case the confidentiality is being breached during the proceedings, during the arbitral proceedings, in that case, the parties have an option to raise an extra claim, a fresh claim before the arbitral tribunal and seek for damages. That is a provision which is always available that is an option which is always available with the parties. However, in case of a breach of a confidential information after the completion of arbitral proceedings, that is after the award has been passed, the parties have an option to initiate a fresh arbitration. They can, because of a fresh cause of action from the same arbitration agreement, the parties can opt for initiating another arbitration and seek for damages. That aside, there is always an option for seeking specific damages, specific relief before the tribunal or or from the court in case of confidentiality breach. Apart from that, another major concerns that probably will be taken up would be with respect to the interim reliefs that we seek from the court, which could be in the form of interim relief under Section 9 or challenge under Section 29A for extension of time period for passing of an award, could be for termination or substitution of an arbitrator under Section 14 or 15 of the Arbitration Act. There, the concern is that all the arbitral record is put before the court. However, even in such cases, there is enough safeguard available in the Indian jurisdiction to protect the confidentiality concerns of the parties. This can be divided into the arbitral proceedings, so the court proceedings, the arbitral award, and the orders which are uploaded in the public forum. With respect to the record which is available before the court, as we all are aware that as practitioners, the certified copy of any record can only be sought by a party who is related to the arbitration. It could be either the legal representatives, the parties themselves, or their authorized representatives who can seek for a certified copy, which has a complete record. No party other than the parties which are related to the matter can seek for the certified copy. And a breach of confidentiality only occurs when a party, apart from the ones which are related to the matter, goes ahead and gets information regarding the arbitral proceeding. As for the orders which are uploaded on the website of the court in cases of Section 9 or Section 29A, etc., even for that, there is no bar in the Indian jurisdiction that restricts the parties to apply for an application under Section 151 of CPC, read along with 42A, wherein the parties can ask the court to keep the orders of the court confidential. And this is not an unknown practice, even in cases of divorce, in case of POSCO hearings, or even in IPR cases, the orders are kept confidential and are a record of the almond. You have to specifically apply for them to get access to those. Finally, in cases of if the concern is related to the ongoing proceeding before a court, there is a concept called confidentiality clubs, which has been slowly evolving in the Delhi High Court and the Bombay High Court. In a couple of cases where the parties believed that the nature of the subject matter of any matter ongoing before the court was of a confidential nature, the parties opted by way of either written agreement or by way of seeking directly from the court to allow private hearings. In these cases, the parties ask the court to conduct an in-camera proceeding, which protects the information if it is of such a nature which cannot be disclosed. Finally, to conclude my stand, I would say that confidentiality can be maintained. It is about case management. If there is enough coordination and cooperation on both sides, and if the parties wish to keep the proceedings confidential, the tribunal can ensure the same. Further, the tribunal and the courts should go over what the parties and the representatives are expecting of a proceeding and should not accept anything less than full compliance.
Thank you, Tanya. I think you went 10 seconds over, but that's fine. I would let the other side also take 10-20 seconds in addition to their speaking time. Now I would request the team speaking against the motion, the first speaker, Kamal, to go ahead and address the motion and speak for his side. Thank you so much. And good luck. You need to unmute yourself. I think it's been quite a long time that COVID has hit us and we've become tech savvy, but this mute and unmute thing continues for a very long time. Anyway, continue, Kamal. Good luck.
Hello, everyone. My name is Kamalkant Thakur. I'm speaking against the motion. Before going ahead the discussion, first of all, I would like to read the section again. Section 42A, notwithstanding anything contained in any other law for the time being in force, the arbitrator, the arbitral institution, the parties to the arbitration agreement shall maintain confidentiality of all the arbitration proceedings except award where its disclosure is necessary for the purpose of implementation and enforcement of award. So I would like to break down this section into three parts. First is this section starts with non-obstante clause, which I will deal later. Second, this section says about the parties who are bound by this provision, like the parties who cannot disclose the information. And third is exception, which is provided only for implementation and enforcement of award. That is section 36 of Arbitration Act. First of all, if we read section 42A, it is applicable only for parties to the arbitration agreement, arbitrator, and the arbitral institution. This section doesn't deal anything in respect of witnesses who are parties to the arbitration proceedings, stenographers, transcribers, and any other person who are part of the arbitration proceedings. So there is a possibility that these people are parties to the arbitration proceedings and they are privy to some information which parties want to keep confidential. But the provision directly doesn't prevent disclosure of that information if we read that section plainly. Secondly, that exception provided under section 42A is only in respect of implementation of award. That is section 36. And there is a possibility, of course, when arbitration proceedings are there's a possibility that parties may approach the court under section 9, section 14, section 11, 34, 37, so on and so forth. And definitely when parties are approaching before the court, they will provide information with respect to arbitration agreement. And there is a possibility some confidential information might be provided in the pleadings before the court. Now, the other side has argued that information is not directly accessible to third party. However, like many of the times we have seen that when the matter goes before the court, it has become a media trial and every information is available to every other person, every third party. Okay. So when the matter goes to the court, there is a possibility like there is a trade secret, sensitive information with respect to pricing, business plans, manufacturing know-how, etc., can become in the knowledge, can come to the knowledge of public, and which will have a negative impact on the business as well as the reputation of the party, because the purpose because of which they enter into arbitration agreement is not only that they want to expedite the proceedings. The intention could also be that they want to keep the proceedings private. They do not want that information in respect of any dispute will come into the public domain. There's a possibility that even competing parties will become privy to that information, price sensitive information. It is important to note that this high-level committee has introduced this confidentiality concept during the year 2017. However, the recommendation of the committee was something different than what has been enacted by the legislature. The intention of the committee was, the provision which committee has recommended was the confidentiality of arbitral proceedings unless disclosure is required by legal duty to protect or enforce a legal right or to enforce or challenge an award before a court or judicial authority. However, the similar provision was not enacted by the legislature, and they have restricted only to one exception, which is implementation of award. And they have ignored to consider the concept of challenging procedure. So what the other side was saying that the provision starts with a non-obstante clause. That means this provision will prevail over other act. However, at the same time, this non-obstante clause will kill the option of party autonomy, because there is no exception in section 42A which allows party to have their own procedure in respect of confidentiality, because there is no exception under 42A which says that if parties have agreed to something else or unless otherwise agreed between the parties, such kind of provision is not mentioned under 42A. Secondly, there is a possibility that certain regulation will require company to provide information with respect to arbitral proceedings. Like for example, for a listed company, certain information is required to be provided with respect to dispute. However, again, the same exception is not provided under 42A. Like my learned friend has said that arbitral institution has provided the provisions for confidentiality. So on that, there are different arbitral institutions in all over India, and every institution is having their own individual rules. And even those rules are not on similar lines, because certain rules provide for publication of arbitral award without the consent of parties, whereas certain rules mandates the consent of parties before publication of such awards. Secondly, even the 42A again doesn't provide any exception for publication of such awards. So again, 42A has been passed by the legislature, according to me, in an unplanned manner without considering whether what other aspects can be there. Finally, consequence on the breach of section 42A. So if we read 42A, there is no consequence provided in the entire act. So without any consequence, no party will take that section seriously, and it will have a negative impact. And as Dilsheen said, party may take it as a directory. So that will have a negative effect, because there is no point of bringing confidentiality if the legislature is not interested in making that section binding on the parties. So at last, I will conclude my argument by saying that there are 4 concerns, according to me, because of which Indian arbitration is not compatible enough to safeguard confidentiality concerns. 1, all 11 parties are not mentioned in the section, like stenographers, etc. Second is exception list, which is provided under 42A, is not exhaustive. My third point is no mechanism is provided when the proceedings are filed before the court. How these proceedings can be kept confidential, like provided in international jurisdiction. The fourth point is there is no consequence provided under 42A, because of which there is a possibility that no party will take this section seriously. And ultimately, the purpose for which this section was brought in by the legislature will not be achieved. Thank you.
Thank you, Kamal, for your thoughts against the motion. I see that there were too many of them. I also feel that you're very dissatisfied with Indian law presently, and you love foreign jurisdictions. Maybe that's a place that you should be in practicing at. That was just on a very lighter note. I would now request Rohan to address everyone against the motion. Thank you. Good luck.
Thank you so much, ma'am. First of all, a very good evening to everyone present in this August House. It's really a pleasure to be a part of this Oxford style debate. Without much ado, my learned co-speaker, Mr. Thakur, has very wonderfully summed up and laid down the groundwork of the fact that we're arguing against the motion today, that Indian arbitration law is not compatible enough to safeguard confidentiality concerns. Picking up from section 42A, which happens to be a very recent development by the 2019 Amendment Act. Let me start off by clarifying this for everyone today, that 42A has been inserted without actually realizing the fact that Indian arbitration law, the practice and procedure of arbitration in India, is far different and distinct from how arbitration is practiced in well-established jurisdictions. And I will substantiate this by a few points that the social muscle and the mindset of practicing arbitration in India is far different. If you look at the wording of section 42A, I think it is very important for me to point out that it is merely a substantive provision that exists in the statute book, which is incapable of being enforced. It does not provide for any consequences in case of any breach of confidentiality. This point brings me to the fact that section 42A is merely a toothless tiger. My learned friends on speaking for the motion had briefly pointed out that in case of fresh cause of action arises, in case of breach of confidentiality, a fresh arbitration can be invoked. But at this point, I would ponder upon the question whether that's the most feasible option. The entire premise and the entire reasoning for coming to arbitration is to expedite the dispute resolution mechanism and to get an award in the shortest time frame possible, subject to the provisions of the Act. However, initiating a fresh arbitration after concluding one arbitration is certainly not commercially viable, and neither will it serve the best interest of the disputing parties. Next, I would like to touch upon the fact that section 42A has more implied exceptions, as my learned co-speaker had pointed out, in case of the parties approaching the court under various sections such as section 19, or from an appeal from section 17 to 37, or challenging the award under section 34. These are the implied exceptions that are inbuilt in the statute far before the provision of confidentiality. Therefore, there are more implied exceptions in the statute than positive assertions or obligations that parties must be executing in order to enforce confidentiality. I understand that section 42A starts off as a non-obstante clause. However, the position might reflect a non-obstante clause. However, in reality, it is actually a non-existing clause in the Indian arbitration landscape. My submission towards concluding on 42A is that merely adopting provisions from international jurisdictions or taking cue from international jurisdictions will certainly not make the Indian arbitration landscape a more robust regime in order to practice arbitration. Neither will it close the gap or make India come on par with international jurisdictions. It is because of provisions like section 42A that do not even provide a mere mechanism for enforcement or a consequence of the breach that makes me think that it is certainly a workability paradox that we are faced with today with respect to section 42A. And to conclude on section 42A, I would just like to point out that it is because of these provisions that makes me think that India is closer to becoming a 5 trillion economy sooner than becoming a hub for an international commercial arbitration. Next, I would like to briefly drive around the fact that if we read the high-level committee report, it is largely influenced with respect to the limited extent of confidentiality. It is largely influenced by foreign jurisdictions and well-established jurisdictions such as Hong Kong, Singapore, and takes a little into account of the United Kingdom. As a caveat, United Kingdom does not have a substantive provision for enforcing confidentiality. The practice in United Kingdom is with respect to an implied practice of confidentiality and not by way of a codified statute. I will now draw and show as to how 42A suffers from inadequacies and how taking a cue from foreign jurisdictions was certainly not the best idea for the high-level committee. Hong Kong Arbitration Ordinance, that is the statute that governs the arbitration law in Hong Kong, provides for statutory measures relating to confidentiality. And I'm not saying statutory measures in terms of merely putting a substantive provision, but it also allows sufficient room and adequacies for the parties to exercise that right of confidentiality. This is in relation to the fact that in case parties approach the courts in Hong Kong relating to an arbitration matter, they always have a right under the law itself to make an application to the court and request for the cases to be heard in a confidential manner. Therefore, which is not present in India. The Act does not provide for such rights. Secondly, decisions relating to confidentiality can also be restricted upon a request being made by the parties. Identical provisions exist in the Singapore International Arbitration Act as well. I come to the point, I see that I'm running short on time. So I come to the point that what and how to protect. It is very important to address this August House about the fact that different considerations apply to different types of documents being exchanged in arbitration. The Act does not contemplate such a measure. There can be certain proprietary information, trade secrets, technical know-how, pricing that might be involved in an arbitration, which is sensitive, and parties will not want this to go in the public domain. To conclude, I would just like to point out that it is because of gross inadequacies in section 42A that makes me feel that it is akin to missing the trees from the forest. And with that, I sincerely hope that my co-speaker and I have tried our level best to maintain the faith of the audience who voted against the motion at the outset. Thank you.
Thank you so much, Rohan. It was lovely listening to your thoughts, however anti-national it may have been. But moving on, I would request everyone to give, let's start with the rebuttal first, or would you like to take rebuttals after the question answers? I would leave that up to the speakers.
Ma'am, I think we can go forward with the rebuttals.
And Dilsheen, are you taking the rebuttals?
We'll divide, Tanya, and I will take 1 minute.
Okay, all right. So I'll request
taking a minute each.
Do you want to go one for, one against, or do you want to go both for and both against?
I think we can leave that up to the moderator.
No, I'm just asking whatever's convenient. Dilsheen, would you prefer one for, one against, Dilsheen and Tanya, or both fors and then both against?
I think we should go with both for and both against.
Both for.
All right, perfect. Dilsheen, I'll request you to start with your rebuttals then.
So I would like to begin by saying that Kamal, I think most of the issues were already addressed by my co-speaker. However, Kamal had pointed out that the section 42A only binds the parties and the arbitrator, and witnesses and stenographer and other staff may be left out. So I would like to say that arbitral institution includes the stenographer and other parties and other staff which forms a part of the institution and the arbitral tribunal. So it's the duty of the arbitral tribunal to protect them. Secondly, to ensure that they are also maintaining that confidentiality along with the arbitrator. The witnesses are again a part of, are also related to the parties themselves. So therefore, it is the duty of the parties, and they become a related party in the proceeding. So therefore, they are also bound to protect the confidentiality by way of 42A. The other thing that Kamal had also mentioned was that this non-obstante clause is restricting party autonomy, and even Rohan had also mentioned that this is essentially a non-enforceable clause. So I already mentioned earlier that this provision is directory, it can be read as directory in nature, does not have to necessarily hamper party autonomy, because if a party is free to decide that they do not wish to have any confidentiality in the arbitration, it is not necessary that this has to bind them. That is not the intention behind introducing this provision. And there are other provisions also beginning with a non-obstante clause. For example, section 238 in the IBC. Now, when the provision was actually enacted in 2016, the effects of reading down that provision were not as such prevalent, and were not aware of how far-reaching the consequences of that can be. So therefore, over time, it has been developed, and 238 has been used to ensure that IBC, being a special mechanism, the proceedings before the NCLT are actually restricted to that, and no other interference is warranted, even if it stands in conflict with other laws. So similarly, arbitration proceedings are also restricted to the arbitral tribunal, and therefore can be taken ahead and forward in that way, and does not have to necessarily hamper other proceedings and other laws. And I think my time is up.
Thank you. Yes, your time's up. But I took into account the 30 seconds which remained before. So therefore, you got slightly extra time. I would request everyone else to stick to their 1 minute time. I've already given everyone else a little bit of extension, barring Dilsheen. Thank you.
I'll address the issues raised by Rohan. So one of his major concern was that Section 42A does not provide for remedies. It is basically a relief without the remedy. That was one of his major concern. For that, I already addressed that the only solution is not to start and initiate a fresh arbitration. If the confidentiality obligation has been breached during the proceedings, then you can always approach the tribunal and ask to add on an issue. Apart from that, if I may bring your attention to Section 34 of the Arbitration Act, particularly subsection 2.5, it says that the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties. In that case, the arbitral award can be challenged. Therefore, in case after the arbitral proceedings have concluded and there is a fear of confidentiality breach, the parties have an option, the opposite party has an option to challenge the same under Section 34, under subsection 2.5, and get that award set aside. Apart from that, your another concern was with respect to what if the proceedings when Section 9 proceedings, Section 29A proceedings, etc., when are brought before the court are of a very confidential nature, the same becomes a part of the court record. Again, the same was addressed by me, that in case the proceedings, only the record are accessible to the parties and the related parties. As for the orders, for orders, we can always request the parties, if they want, they can always request the court to keep those orders confidential.
That's it, Tanya. I would request it's in fact 40 seconds over.
Just one line, ma'am. I'll conclude it with that. And with respect to the proceedings, ongoing proceedings, there's a concept of confidentiality clubs that I had already explained to protect the interest of the parties. So therefore, I feel like there is enough safeguard if the parties want to address their confidentiality concern in an arbitration.
Thank you, Tanya.
Thank you, ma'am.
I would request Kamal to now take the rebuttal.
Hi. First of all, I'll take points of Dilsheen. So Dilsheen has said that the provision provided under Section 42A is directory in nature. If we read the section starts with non-obstantive clause. Secondly, it uses the word shall. So by reading the provision, the interpretation, according to me, comes as that it is mandatory rather than directory. Even if we consider the argument of Dilsheen that it is directory in nature, that shows that the party has a liberty to either follow Section 42A or not follow Section 42A. Because if we treat it as a directory in nature, that means party is not obligated to follow 42A. That means there is no confidentiality which is binding the party. There is no obligation for the party to follow 42A if we read it as a directory in nature. Secondly, what Tanya has said, that there is enough safeguard in respect of approaching courts under Section 9, 11, 14, etc., etc. According to me, there is no mechanism provided under Section 42A which says, which is provided like in Hong Kong arbitration, wherein parties may request the court to keep the proceedings private in nature, which is not provided under Section 42A. So according to me, there is no enough safeguard which is there for the party. And secondly, like if any order is passed under Section 34, most of the times we have seen that the judge provide entire detail of the award in the order, which is uploaded on the website, which is accessible to any other party. So the information is not in private. The information is accessible to anyone. if the award is uploaded on the website of the High Court.
That's it, Kamal. Thank you so much.
Thank you.
I would now request Rohan to take his part of the rebuttals, please.
Thank you, ma'am. I'll quickly get to this. There are two concerns. One, confidentiality clubs. As far as these clubs are concerned, these are practices and they are not codified anywhere. As far as countering these confidentiality clubs is concerned, I would state that there is another exception to the doctrine of confidentiality in arbitration, that is balance of interests, which the courts have to make. That is to distinguish between private interests and public interests. Let me quickly substantiate this with an example. The disclosure will be necessary in cases of public interest where the public at large might be affected by the ongoing proceedings despite them being in arbitration or culminating out of arbitration. For instance, a dispute between two PSUs involving public money. Why would that not be in the interest of the public at large? Secondly, regulatory exceptions. It is very important to note that in case a legal duty is cast upon by some other laws, for example, the RTI Act, which a very recent decision culminating out of the CIC has fortified this fact that they ignored 42A and they've provided the entire arbitral record to the third party. Lastly, I would like to point out that there is a difference between court proceedings and the court record. Similarly, arbitration proceedings and arbitral record. Not everything said or done in the courts or in arbitration are always recorded. That always needs to be kept in mind, that different considerations might apply to different classes of documents. And I'm speaking about documents, not arbitral proceedings. Thank you.
Thank you, Rohan. First and foremost, I would like to thank all the speakers for taking out time and giving this topic this much attention that they've given and researched about it and all. And that's something that I'm really appreciative of. More often than not, I understand that, at least young people like you guys have a lot on your plate. And as a result of which, you guys do not have that much time to take out. And from your busy schedule that you guys have, in fact, taken out this time and devoted towards this debate, all of us are really appreciative of. While I say that, I would now request everyone, whoever has a question for the speakers, we can take those questions up. Any question which anyone may have, they can put it in the chat box. I can read it out and ask. And if it is also towards one side, you can indicate that. If it is specifically to a speaker, that also can be indicated. If there are no questions, I have many. So I can in fact ask for each speaker, I've written down a lot of questions. So I can start with my own question. I'll wait for 10 seconds and then we can in fact take my questions up. I know that Vivek had a question because that's something that he messaged me. Okay, Vivek has in fact written his question. Question for the team for the motion. Either of you can take it. You can. I'm reading the question aloud. You believe that Indian arbitration law is compatible with confidentiality concerns. Then why were the 2017 high-level committee recommendations, such as where disclosure of arbitral proceeding is required by legal duty under law, not adopted by the legislature? Either of you can take it, Dilsheen or Tanya.
Tanya, you want to take it?
All right. So with respect to that, the high-level committee recommendation did not adopt the wording particularly that where disclosure of arbitral proceeding is required by legal duty under law is keeping in mind the public interest at large. Of course, this is an exception which is prevalent all across the legal, all across the statutes, across provisions, that when there is something which is mandatory required to be disclosed in the interest of public, that has to be done. But apart from that, if the dispute is of a private nature and the same requires confidentiality because of the nature of the dispute, because the subject matter of the dispute, there are definitely enough safeguards in the Indian arbitration law to protect the same. This is an exception which has to be there and will always be there regardless of any enactment.
I would, I in fact have a follow-up question. Either of you speaking for the motion can answer that question. Now, in 2019, 42A was introduced, but also the amendment to Section 34 was introduced, which went ahead and said that it has to be on basis of the arbitral record. So in a Section 34 petition for setting aside of an arbitral award, what you really need to show is that, and from the arbitral award, that there has been a ground for setting aside such an award. So it is only limited to arbitral record. Now, in one breath, there was an enactment of 42A going ahead and sort of taking care of confidentiality concerns. But at the other hand, there was in fact an antithesis to it in Section 34 itself, which went ahead and said that it has to be established basis the arbitral record. I mean, how does that get reconciled? I mean, according to me, the answer of it would have been because of the enactment and amendment in Section 34. But the question really is, why was this not adopted by legislature in the manner and form which the high-level committee recommended it in 2017? Either of you can answer. I mean, it's just directed to Dilsheen and Tanya. Either of you can answer. I mean, what is your point of view on it? I understand, of course, like we have no say in what in fact gets enacted, but what is your point of view?
So I think like Tanya had mentioned earlier, the arbitral record, even in the Section 34 petition, will definitely be a part of the petition. However, again, the petition filed before any court is not a public document. So those proceedings are just between the court and the parties and are protected under the Evidence Act also. So anything, like she already mentioned, they cannot be obtained by any other party. A certified copy of that record cannot be obtained by anybody else who is alien to those proceedings. We all are aware that even if we apply for a certified proceeding, so much so that is even in the district court, the wakalatnama and everything else is verified. The proceedings, therefore, and the arbitral record is definitely not a public document, and they are definitely protected even in a 34 petition.
Okay. Thanks for that answer, Dilsheen. There is another question for the team speaking against the motion. Section 42A says and uses the word, and I'm quoting Section 42A, shall maintain confidentiality of all arbitral proceedings. Where is the interpretation of any implied reference that the same has no binding effect to the stenographer or the third parties, etc.? And I think that's more or less directed towards Kamal, because that's the point which Kamal had made during his speech. So I would request, in fact, Kamal to answer this question.
Yeah, if we read Section 42A, so Section 42A specifically provides the parties which are bound by the confidentiality. So the parties which is mentioned under Section 42A is only arbitrator, arbitral institution, and the parties of the arbitration agreement. There is no reference to stenographer, transcribers, or any witness who is attending, expert witness who is attending the arbitration proceedings. So there is a possibility that they might share some information which is relevant during the arbitration proceedings because they are not bound by this provision. So that's why, since...
Can I have a follow-up question here and interject you, Kamal? And I'm taking it from what Dilsheen had answered this in her rebuttals. She made a very valid point when she said that any person, and I'm just paraphrasing it a little, any person who are the third parties in an arbitration referred to as stenographers or transcribers, they are in fact appointed by either the arbitral institution or the arbitrator or by party. So by implied agency, they would be in fact bound by this confidentiality concern, and that's something which Dilsheen had answered to it. Do you have a counter to that?
I
Because
think
see, the payment itself shows, right? Parties
Hmm.
are either paying for it, or arbitrator himself is paying for such a person in certain scenarios, or
Correct.
the arbitral institutions are the ones who are in fact appointing such personnel. It'll be interesting to know what you have to say because of this implied agency which the screen was talking about.
I think in respect of witness, I think since there is no express provision, even if the payment, so for example, if there is expert witness which has been hired for the arbitration and the payment is made by the parties for his guidance, whatever the arbitrator is required. But I think since there is no specific bar which is provided, so there is a see, then the question is left to the court to determine that fact. And like it is not specifically provided in the section, it is something which is required to be interpreted. Because, like for example, in a situation where any expert witness shares some information to any other competitor, he can always say that this section is not binding on me. It is something which Dilsheen has said is some kind of an interpretation which we are taking. But since there is no express provision or specific mention about that party, so there is always possibility that he will share the information and he will say that I am not bound by this provision, because that is
I
something
see.
to be decided by the court. Matlab, by reading the provision,
I
something what
understand.
you are saying and what I am saying is an interpretation to it.
I
Ma'am, if I
understand.
can just be permitted to just add on to your question.
Right.
So, ma'am, you specifically pointed out that either they're appointed by the parties or by the arbitral institution itself. My only concern is then why is 42A so rigid with respect to the stakeholders in with respect to confining them only to the arbitral institution, to the arbitrators and the parties? Why do we have to read everything into 42A? That was our whole argument, that the inadequacies of 42A are so large today that it fails, not just fails to consider implementation, but also the lack of stakeholders involved in the arbitration process. So even though I understand that, for instance, if a stenographer is appointed by the arbitral institution itself, they're merely bound by good faith practices in India, as far as India is concerned. However, coming back to the same point, that these are myriad of exceptions to 42A, which could have been left, and India would have been fine without 42A as it stands today. We could very well be in line how confidentiality is practiced in the United Kingdom, which expressly mentions that there are a myriad of exceptions to confidentiality. So that's my input on your question.
I see. There is another question. Thanks, Rohan. Thank you so much, Kamal. There is another question which is there for, and the question before was in fact asked by Namrata. Now, Naman has asked a question. The question is for the team speaking for the motion. And the question is, upon the filing of Section 34 petition, the court calls upon the arbitral record, and the moment the same is placed before the court, it becomes a public document. In such a scenario, how will Section 42A come into picture?
Ma'am, to address this question, I'd just say that Section 34, of course, and not just in Section 34, but the same happens when Section 37 appeal is filed, or even when interim relief is sought by the court. In that case, a lot of the documents come before court, and it can be said that that becomes public record. However, as I said, that the record per se is kept with the court, and only people who are related to the matter can get access to that by way of applying for certified copies. With respect to the court orders per se, as I said, that there is no bar under the Indian arbitration law or otherwise that restricts the party to file an application specifically requesting the court to keep the records confidential because of the subject matter of a case. And because Section 42A puts an implied duty of confidentiality, so this read along with 151 would give parties a little more power, statutory power, to ensure that the courts allow to keep the court records confidential. And as I also mentioned about the confidentiality clubs, this is a fairly new concept which has been adopted by in a couple of cases by the Delhi High Court, and even the Bombay High Court has adopted this, wherein when the parties particularly plead before the court, either by way of written agreement or by way of seeking liberty of the court allows in certain cases to keep the entire record confidential. What happens in that is they allow only the related parties to be a part of those proceedings. And because those proceedings are of a private nature, it is done in camera. So there is an option available to the parties in case they feel that the nature of the record is so confidential that it should not be released out in the public. The parties can opt for something like this. This mechanism is available, which is slowly getting evolved and being adopted by courts. And just to add on a little bit more to what Kamal sir was saying with respect to the steno and the witnesses, same as ma'am said, that in cases of institutional arbitration, the stenos and any administrative person is involved, directly responsible to the institution, and the institution is obligated towards the parties for a confidentiality obligation. In case of an ad hoc, all of the administration is considered to be a part of the tribunal, and tribunal is covered under section 42A, which has an implied duty of confidentiality vis-a-vis the parties.
Thank you. Thank you so much, Tanya, for your answer. I have a follow-up question. I see that the discussion today had become extremely academic, barring a few observations which were in fact made by all the speakers. So I would really want to ask the team speaking for the motion, are there any case laws where such enforcement has in fact taken place of confidentiality concerns? Is there anything where a breach of confidentiality, specifically section 42A, has been spoken about either by Supreme Court, High Court, any district court, in fact, where this provision, which was introduced in 2019, in fact, been enforced? Do we have any of that data before us?
So, ma'am, the provision has not been invoked before any of the courts. It's been fairly recently introduced in 2019 and has been notified even later. So there is not much to say that the courts have actually been cognizance of this, or there has any proceeding where this provision has been invoked. But that also actually points to the fact that there has been no need to actually go ahead and invoke the provision, because again, that the argument behind this entire the motion is that the Indian arbitration law is actually compatible. So then again, there is an implied understanding of confidentiality. So there has not been a need. So the absence of any such invocation of this provision actually points to the fact that there has been no need to invoke this, because the arbitration system has been sufficient enough to ensure that confidentiality is safeguarded and protected against just by an implied understanding.
Thank you, Dilsheen, for that answer. I may have reservations to it, but it was a very well-crafted answer. I have a very quick follow-up questions for the team speaking against the motion, which relates to this question. Now, today's motion was that, are there enough safeguards in the Indian law when it comes to confidentiality concerns? It, of course, means that whether the law which stands today is adequate in nature, including the point which Dilsheen and Tanya have repeatedly made of implied confidentiality agreement between parties, which in any event can be taken as a civil wrong, etc. Right? Now, that doesn't mean if the parties themselves don't choose to enforce these rights and remedies which are available to them under law, it wouldn't come in the ambit of today's motion, at least. I understand that there may be some resistance which are there by the parties, but if the parties themselves don't exercise their rights, it can't be said that Indian law, as it stands today, does not have adequate safeguards. And I would really direct this question to Rohan, because he had touched upon certain aspects in relation to this.
Thank you so much, ma'am, for that question. Yes, I I am in agreement till the limited extent that if the parties do not wish to exercise this right of confidentiality, then we cannot possibly blame our own legislative framework for that. However, the parties should at least have sufficient opportunities and avenues to exercise these rights in the first place. there has been a lot of discussion about confidentiality clubs. And as I said, there has to be a codified way as to how parties can exercise these rights. In the absence of the black and white letters of the statute providing for such exercise of rights and the mechanism involved in the exercise of such rights, I am uncertain to the fact that parties would actually be mindful about exercising this right of confidentiality in the first place. So today, as it stands, and I agree that if the parties do not exercise, there is possibly no one to blame. But I would also point out that if the legislature does not provide certain avenues for them to exercise these rights, then you cannot also possibly blame the parties for it.
So according to you, what should be the ideal law of India? And what are the safeguards that we're talking about? I understand that, certain specific scenarios have been pointed out by the team speaking for the motion, but I personally felt that the team speaking against the motion has shied away from giving specific examples as to how the present law of India should look like when all of these safeguards that you guys have been talking about are included. So if you could answer that, that'll give us extreme lot of clarity.
Thank you so much, ma'am, again for the question. My only point, and I briefly addressed this in my
towards the end. That's right.
Yes, towards the end also, that
right.
India would have been fine without 42A today. We would have been absolutely fine because the insertion of 42A has left us with more questions than answers today. In an ideal scenario, as your question was specifically pointed out, we could have been very well in, if we actually wanted to take such a huge inspiration from well-established jurisdictions, we could have been very well in line with the United Kingdom, which do not provide for a codified law concerning confidentiality. It leaves it open to the parties. There are implied exceptions. There is a scope to which they are also limited. There are a myriad of exceptions. And ma'am, I would also like to point out that there was an identical committee in the United Kingdom which had deliberated upon confidentiality, whether it should be incorporated or not. It was the wisdom of the lawmakers in the United Kingdom that thought in the best interest of arbitration to not include this in the legislature. And in my opinion, that should have been India's approach as well. The high-level committee.
Sorry, Rohan, I think I'd missed a question from Naman in the chat box. This is for team speaking for the motion, Dilsheen and Tanya. This is the last question that we'll take up and then we'll wrap up. The question is, Indian Contract Act is silent about breach of confidentiality, and the law of breach of confidentiality has not evolved much over the period of time. Hence, in such a scenario, how will 42A standalone protect the breach of confidentiality? And I think this is more or less directed towards Dilsheen because she was talking about implied confidentiality. So if Dilsheen could address this, it'll be helpful.
So Contract Act and in the contract and the legislation has to go hand in hand. Of course, an arbitration, solely the Arbitration Act cannot protect confidentiality by itself alone because the agreement has to supplement it. And again, because the arbitration in itself arises out of the contract. So if we look at Section 27 of the Contract Act, it says that any agreement in restraint will be void. So in case that also, just to protect confidentiality, there is no bar in adding that the provision in an agreement. So the provision actually supplements it because there has been no bar or prohibition to add it in the agreement even earlier. And however, in absence of any such provision in the agreement, the provision in the Act can supplement it and protect the party.
All right, thank you. I'm so sorry. I had this really cool question, which was something which I thought is extremely crucial for this discussion, and I flipped that page. And that'll be the last question, I promise. So my question is that 42A, and this is for the team speaking for the motion, unfortunately, because I feel a lot of questions have come your alley. The question is that 42A forms a part of Part 1 of the Arbitration Act. However, there is no 42A which is there in the Part 2 or a similar provision which is there in Part 2 of the Act. So if we go ahead and say that Indian law as a whole has adequate safeguards or not, we also have to see Part 2 arbitration arbitration context where enforcement is sought. So in that scenario, I feel there is no provision at all in the Arbitration Act which protects confidentiality. Is there something that you would want to add on to this and answer? Dilsheen or Tanya, any one of you can answer this question. Tanya can go ahead and answer because Dilsheen just answered the question.
Yes, ma'am. Thank you for the question, ma'am. Ma'am, Section 48 of the Arbitration Act, which is conditions for enforcement of the foreign award, particularly subsection D of 48D, it says that the composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties. In that case, the enforcement of the award can be challenged. So if the parties are not, if the agreement between the party has a confidentiality clause and there has been a breach of confidentiality, then in that case, if an award is being enforced in India under Part 2, there is a provision under the Indian Arbitration Act which provides for a challenge in such a scenario.
I understand, but that'll be presumptuous, as in you're implying that there has to be a confidentiality clause between parties. It's only in that scenario that this would become relevant. But I do understand your point. Let's now go to post, unless you want to say something, we can go ahead with the post debate votes.
Ma'am, that's it. But also, just to add a line to that, is that there is an implied duty of confidentiality in India. So if there is a breach, so then again, regardless of whether there is a provision in the whether there's a clause in the arbitration agreement or not, parties will have an option, a sufficient cause to challenge the same when executing it before, when enforcing it before Indian courts.
That's right.
And if I could.
You. Okay. Yes. Last line.
Add one last thing regarding what Rohan said. So he earlier pointed out that there is no black and white with respect to what exactly confidentiality means in India. And then later on, he went ahead to say that we should have adopted something like the UK has adopted, which is that they have kept silent on that. And they have let the laws, the conduct between the parties to establish a more proper regime regarding confidentiality. So that is contradictory. And also, coming back to the provision 42A, the reason why it is left a little vague is to allow the parties to interpret it. And because it's an Indian, we are talking with respect to Indian jurisdiction, it's a common law jurisdiction which allows courts to make allows the court to make precedents basis the provision. So it's not necessary to have a black and white provision, a statutory provision, to have a proper codified law with respect to confidentiality.
I see. I think before the end of the debate, formally everyone has started voting, but we'll take these votes into account. I would first thank the speakers for doing such a great job and well thought out answers. In fact, few of the answers I thought were very crafty, very nicely answered. So thank you so much to all the speakers and to everyone who's in fact present to watch this debate, to be a part of this debate. And hopefully even next time we'll have such a good participation. The votes, the post debate votes are already coming in. I don't, well, at least it seems like that there would be a huge swing, unfortunately, for the team speaking against the motion. I mean, in any event, the team speaking for the motion has won because they'll have more swing votes irrespective. If it was 4 in the beginning, right?
Yeah.
So anything over 4, they'll win. That's why I think next time onwards we shouldn't do Oxford style.
They've already won.
Yeah. I mean, they won in the first 5 votes only.
Yeah.
But let's just wait for everyone to answer. Congratulations, guys. I see you guys are not excited about it. You're not happy. I do understand it's not a huge achievement, but I mean, from where I look at it, I think it is quite phenomenal that you guys managed to shift so many point of views in your favor. I think that shows how good as lawyers you guys are and how persuasive you can be.
You're happy that at least your vote is still against.
I mean, it would have been extremely hard for anyone to change that because I mean, I do believe in against the motion generally. So I do understand that there are a lot of lacunas. And in fact, I also am a firm believer of the fact that when it comes to a common law nation, because there is stare decisis and judgments are precedents, I feel it becomes extremely impossible for a common law nation to have confidentiality in place. It's not like civil law. So, I mean, civil law can really manage without it, but because it's precedent based and stare decisis is something that is embedded in our constitution, I feel it's extremely impossible for us having confidentiality in place. Because in any event, like you said that, oh wow, people are still playing Diwali. Uh, in any event, judgments, like you guys said, form form a part of like a lot of arbitral records are in fact extracted in those judgments. As a result of which, I don't think it's possible for a common law nation. But that's just me. What actually remains right now, and I love this power which has been bestowed upon me by none other than Pinto. I don't see my source of power coming from anyone else. Is that I need to declare the best speaker for this debate. And I mean, I think that's the only reason that I go ahead and moderate these debates also, apart from the fact that I like it. I think, like judging people. Pinto, can you calculate the post-debate result and give me an answer? I mean, I think it's already very clear, but we'll still have a number. Ouch. Congratulations, Dilsheen and Tanya. It's official. You guys are winners for today's debate competition. Now, the best speaker is, of course, you can have a round of applause for everyone who's won today's debate. I wish I could play something that would have added for it, but I can't. Congratulations, Dilsheen and Tanya. You guys did a phenomenal job. I mean, the swing votes itself show that you guys were extremely persuasive. You guys, in fact, put in a lot of hard work, and I'm very proud personally. And I, in fact, had this belief that the all girls team should have won. At least at the back of my head, I didn't say it, so I'm quite appreciative of that as well. Thank you so much for making that happen with your hard work. Now, for the best speaker. I feel that, sometimes this power is absolutely unfettered and there is no checks and balance, but I mean, I don't really care. The best speaker, according to me, for this debate competition was Rohan. And why I say so is because I really liked how he drew a lot of um, parallel from foreign jurisdictions and he tried to at least build an argument, not in isolation to India, but even going ahead and giving us holistic picture of arbitration world. For which reasons I feel Rohan is today's best speaker. Congratulations, Rohan.
Thank you.
Good luck. Okay, even Pinto is going ahead and congratulating you. But good luck for future, and I hope you guys continue to do well. Thank you so much.
Thank you.
Thank you so
Thank
much.
you. Thank you so much, everyone.